Good afternoon, all. Thank you for joining us. My name is John Woods, Chairman of International Partnerships for the National Bar Association. Our program, Excessive Use of Force in the Black Community, will be examining this issue from an international law, international human rights perspective. There are three phases to our program. One, we'll frame the issue through the comments of Congressman Hakeem Jeffries. Two, we'll have a technical presentation from the United Nations as well as Amnesty International. And three, we'll synthesize that information through a panel discussion with our panelists. Now, let me take this moment to introduce our incredible panelists, beginning with Christina Roth. Christina, please give us an overview of who you are and your association.
Well, thank you so much for having me, and it's a pleasure to be not only with friends, panelists, but with such esteemed company. My name is Christina Roth, and I am the Senior Program Advocate at Amnesty International USA for our criminal justice program, which is our historic work to abolish the death penalty everywhere that it exists. My work is domestically focused, but of course with the international framework in mind. And of course, our work on police use of force has been really the cornerstone of our police accountability work.
Thank you, Christina. Andres Perez.
Thank you, John. And good morning, good afternoon, or good evening to everybody, wherever you may be. It's a real honor to be here and a real pleasure to be among these distinguished panelists to discuss something that is so compelling and so relevant for all of us, globally and particularly in the United States as of late. I'd like to thank Howard University for opening its doors to UN human rights. And I'd also like to thank Professor Woods for chairing this and for his kind invitation. I'm a lawyer and human rights officer for the United Nations Office of the High Commissioner for Human Rights, where I work for the Rule of Law section, which is essentially OHCHR's legal team. And as part of my duties, I'm responsible for the impact, for assessing the impact and working on the impact of human rights, of weapons on human rights, also torture, detention, and most relevant for our purposes today, use of force by law enforcement officials. Thank you very much for having me. I'm looking forward to this discussion, to contributing, and above all, to learning from each of you.
And again, thank you for joining us from Europe, by the way. Also, Captain Sonia Pruitt.
Good morning, and thank you so much for inviting me. Howard University, I am an alum, so it's my home, so I really appreciate that connection. I am a retired police captain from Montgomery County, Maryland. I currently am a professor at Montgomery College in Montgomery County, Maryland, where I teach in the criminal justice discipline. I'm the past chair of the National Black Police Association, and I'm also currently the founder of a venture called the Black Police Experience, whereby we use history and in order to empower the Black community in particular, but everyone, so that they'll understand the intersectionality between the police and the Black community. So that's what I'm up to now. I really appreciate the invite. I'm excited because I know I'm going to learn so much, and I'm in such esteemed company. Thank you.
Thank you. And of course, last but not least, our president, C.K. Hoffler. Now, what's important about President Hoffler, not only does she hold the distinction of being the president of the National Bar Association, but she's also the chairperson for Rainbow Push Coalition. And in fact, this panel is the brainchild of President Hoffler. In her multiple capacities, she's always championed and pushed for this issue to become more of a focal point in the international human rights arena. So President Hoffler, please. You're muted. There you go.
I have to say, no matter how many of these I do, I start off, I just get so excited. My apologies. I want to say, to Chairman Woods, thank you so much, to you, to Howard University. And I got to pause and say, our Vice President's alma mater, Howard University, and Captain Pruitt's alma mater. I want to thank you all for facilitating this panel. International issues, whether it's surrounding police brutality, COVID-19, or voter suppression, which are the three areas of focus for my administration this year, are a particular passion of mine. So Chairman Woods, I want to thank you for all the work that you've done, all the work that you're going to do in working on our international conference that's upcoming. And I want to thank you for assembling this extraordinary panel. To Christina Roth from Amnesty International, the role of Amnesty International in ensuring and protecting those really who can't protect themselves is extraordinary. I first encountered Amnesty International, I think when I was in college. I did some volunteer work, and so I'm just so delighted that you're here, and welcome. To Captain Sonia Pruitt, there's nothing more impactful than having law enforcement, even if it's retired law enforcement and experts, to talk about excessive use of force and police brutality. Because as I've always said, as we tackle these issues, we must have an understanding from within as well as outside. So we thank you for your participation. To Congressman Jeffries, who's going to appear via video, he is extraordinarily, we appreciate him. The National Bar has done so much with him. He has given of his time to address so many issues. And we know that today, like many members of Congress and the Senate, he is uniquely focused on a little hearing that's taking place right now, that where all eyes are on the world, and we certainly appreciate him, and that he took the time, despite how busy he is, to welcome and to address this issue and frame the issues for us. And then I want to say, not last but not least, I want to say to Mr. Perez, who joins us from a town outside of Geneva, Switzerland. And I have to do a special appeal to him. Some of you may know, but most of you do not know, that I did grow up in a town called Versoix outside of Geneva, minutes away from where he's living, where he's joining us from. When I grew up really in Switzerland, and then I did a year in college at University of Geneva, and I did some courses at the Graduate Institute there. And over the summer, I worked at the UN. Don't ask me what I did, because I'm pretty sure it was not substantive, but just being in that environment as a college student was so remarkable for me. So I've been keenly focused on an international perspective on some of these issues that plague our country. You all have heard me talk about 3 pandemics: voter suppression, COVID, and the third one is police brutality and excessive use of force. So it's against that backdrop that I welcome everyone, all of our family at the National Bar Association. We are recording this because there are many people who couldn't join, but this is just step one, ladies and gentlemen, of what will be an exciting conference that's going to happen. More than likely, I don't have the date in May, but it's going to be in May, where the National Bar will take leadership again in exploring issues of international importance. And taking our rightful place. We're also going to invite other affinity bars to join in with our efforts in that conference. And we indeed want to have the eyes on the world so that people understand that the National Bar takes these issues that have international ramifications very seriously. So thank you. I think I exceeded my 2 to 3 minutes, but I just wanted to share that and welcome everyone to what is going to be a magnificent panel. And again, thank all of you all for participating.
Thank you, Madam President. Your time is unlimited, and you delivered as always. We appreciate that. All right, let's begin to frame the issue. As President Hoffler stated, the congressman attempted to be here, but as with most folks in Congress, their hands are tied. But he was kind enough to provide a video to help us frame this issue of excessive use of force in the Black community. Here's the video.
To Professor John Woods, the National Bar Association, Howard University School of Law community, the panelists, including my good friend, the great Attorney General of the state of New York, Tish James, and all those participating. Welcome to this tremendously important webinar on the excessive use of force in the Black community. There's been an awakening in many parts of America in the aftermath of the tragic murders of Ahmaud Arbery, Breonna Taylor, and George Floyd, that this issue of police violence must be addressed decisively. Police brutality, and the excessive use of force is a racial justice issue, a criminal justice reform issue, and a human rights issue. Because we know that unarmed, innocent, law-abiding African Americans are disproportionately targeted and subjected to police violence and the excessive use of force. And this has gone on for far too long. Year after year, decade after decade, century into century into century. We know that during the March on Washington, a young John Lewis, then the chair of the Student Nonviolent Coordinating Committee, spoke about being tired of being beaten by the police. That was approximately 2 years before Bloody Sunday occurred on March 7th of 1965, when John Lewis was nearly beaten to death and many others were overrun and stampeded by members of the Alabama State Troopers. And so, yes, this is an issue that we have to address in the United States Congress, and we're working hard to do that. We will pass the George Floyd Justice in Policing Act so we can begin to ensure that there's accountability whenever a police officer crosses the line, both in the context of criminal prosecutions as well as civil liability. Overall, we want to make sure that we can bring about a shift in policing in terms of the mentality that presently exists, which is far too often a warrior mentality, where people within the African American community are often viewed as enemy combatants. And we need to shift to a guardian mentality, where people within the African American community and every community are embraced by law enforcement and viewed as partners in helping to improve public safety for everyone. And we need to make sure that every available forum is utilized to bring this to bear. And that's why this critically important discussion about the role of the international community, the role of the United Nations and the Human Rights Commission is available to air out these concerns, to bring international pressure to bear on doing the right thing here at home and across the country and world in places like Nigeria and others. So thank you for giving me an opportunity just to share some opening thoughts and remarks. Have a wonderful webinar discussion. God bless you, and God bless the United States of America.
All right, great words from Congressman Jeffries. Now, we frame the issue somewhat. Now let's look at it from a technical standpoint in regards to domestic law and international law. Christina and Andres, please, I believe Christina, you're going to go first, is that correct? Amnesty International will not only give us an overview of domestic law as it pertains to this issue, but also how it transitions and translates to international law and standards. Christina, thank you.
Can you see the presentation? Okay, you never know. We all have lots of practice with this, but that doesn't mean we get it right every time. Well, thanks again for having me, and I'm going to go over a bit about how international, really law enforcement use of force standards react or interact with our domestic laws, or sort of compare and contrast the two things. And I neglected to mention this in my introduction, but it's my role to work with both state and the federal legislatures to try to better enact law that meets what our international standards are. So first, I was asked to provide a bit of clarity about some terms and difference of usage of words as we see here. Traditionally and often in US media coverage and politicians alike use the term police brutality just as a point of clarity. Traditionally in the international stage, we try not to use that term. I've given an explanation here, but essentially it's not a term of art, and while international legal term of art. And while as individuals we may witness and perceive acts to be brutal, it's not something that could be standardized. And so in our communication, we try very carefully to identify particularly what has happened. Has force been used excessively? How could it be used? And that we recognize that the term brutality may range from something as simple as possibly a discriminatory stop to a police cause fatality. And with that range, we'd just like to be more particular about exactly what transpired. And so you may notice that Amnesty's communication traditionally doesn't use the word brutality. However, that is often how it is described. Just wanted to put that out there in advance. So from a very top level perspective, we all have human rights when we interact with law enforcement. And those core human rights are a right to life, a right to security of a person, a right to be free from discrimination, and to be equally protected under the law. These obviously sound pretty similar to some of the domestic rights that we have. And I'm going to cover some key, though Andres will cover more, of the key principles that are drawn out from international law and standards. These are really focused on one of the key standards, the basic principles of use and force of firearms. These terms are not listed necessarily in order, but in a nomenclature that's easy for me to remember is make a plan, is that force should be used in a way that's proportional. It should be legal. There should be accountability if force transgresses what the law is, and that force should be limited to only when necessary or necessity. So I've broken a lot of PowerPoint rules here. There's a lot of text on this slide, but it's important for us to take a look at both what our domestic laws say and our international laws do to really understand where the gaps are so we can better close them. Of course, the standards that most of you are probably familiar with on the domestic stage are our two Supreme Court cases, Graham versus Connor from 1989 and Tennessee versus Garner. The cases set out what sort of is generally considered to be an objectively reasonable standard or reasonableness standard. That is, these cases represent the law of the land. There are some states that go beyond these, but for the most part, states' laws are written to reflect this. We don't have a federal statutory use of force law, and so they also reflect what these cases lay out. And I'm going to spend a bit more time here on the international standard side, where we have that force should be limited to as a last resort in order to protect an officer or others from death or serious injury, which is not explicit in our domestic law. There's no other means that are likely to achieve a legitimate law enforcement objective or task. Less lethal or lethal force, if it's unavoidable, must be no more than is necessary, which is intended to mean a minimal amount, or proportional to achieve a legitimate law enforcement objective. And finally, that law enforcement must use force in a manner that's designed to minimize damage and preserve human life, ensure medical aid is provided as soon as possible to those that are injured or affected. And again, we don't see these things in our laws, which I'll get to momentarily. So as an overview, I'll say that in 2015, Amnesty International released a report, the Deadly Force Report, which looks specifically at use of force statutory laws in the US. We looked at all of them at the state and federal level, and basically found there's only 41 states that have a law at all. And of course, at the federal level, we just go off of the Supreme Court cases that I mentioned. And so it's important to recognize also the variance between these laws in various places. So the really goal of the report was to compare our laws against the international standards that are laid out in sort of these key plan principles, and more specifically through the basic principles of use and force in firearms and other standards, which Andres will cover. But then none of our laws meet international standards. So obviously I have a lot of work to do, which I hope to partner with you on. So that is the key finding of the report. We also found there are 9 states that don't have a use of force law at all. Maryland is one of them, and I've been working with Captain Pruitt to try to change that. So we certainly have taken advantage of that information. Only Delaware and Tennessee allow police or require police to exhaust what is deemed a reasonable option before resorting to deadly force. 9 states allow deadly force to be used to suppress a riot, which is particularly concerning in light of the events and the many protests we saw over the summer, largely peaceful, that is, in support of Black lives. And finally, that Delaware, Hawaii, and New Jersey require officers to create no substantial risk to a third party. And so oftentimes when we see the use of a gun and excessive amounts of shots fired, we worry about those bullets going outside of the intended target, right? When we think about the Breonna Taylor case, we learned that there were shots that landed in her neighbor's apartment, and in some ways that's quite dangerous. It could have really caused an unintended consequence, harm or serious bodily injury or death to her neighbors. And then finally, this map just shows that there are really just 8 states that require in law that officers provide a warning when. All right, so necessity is one concept, and I'm just going to say out loud, I'm getting a flag that my internet connection is not great, so someone flag for me if I could have, please. Necessity is one principle I'm going to focus on of the 4 I highlighted in the beginning of my presentation. And basically, the key concept from the UN Basic Principles of Use and Force of Firearms to take from here is that law enforcement officials carrying out their duties shall, as far as possible, apply non-violent means before resorting to the use of force and firearms. They may use force and firearms, only if that means remains ineffective without any promise of achieving the intended result. And so I've chosen to highlight this particular component because I'm starting to see a pattern in the states of trying to enact a standard that is not reasonable, in line and in keeping with Graham versus Connor, but actually one that's necessary. And while that's wonderful and Amnesty supports it, I also want to draw a distinction between what that means in our domestic legal context and what it means in the international context of necessity, and that they're not necessarily the same, pun intended, but I'm working to try to make them the same. So in order for us to meet or get close to the necessity principle for international standards, it needs to be outlaid in law with 3 key components, which are qualitative, quantitative, and temporary or temporal. So the first component is qualitative. Is force necessary at all? Is it possible to achieve a legitimate law enforcement objective without force? And I'll note, and Captain Pruitt may speak more about exactly what is meant by force. Force could be something as simple as talking with verbal communication with individuals. So in this slide, that's not what I mean, but rather that, is there a way to resolve a conflict without physical force? And in my assessment of the state's laws that exist, the statutes, there's not a state that makes that element clear at all. So that's a huge gap in our laws and our efforts to achieve a necessity standard. And some phrases I think that could help go a long way towards that end are identifying that imminence is important, is a requirement to be used within the context of deadly force, or there's language that suggests the situation should be stabilized to reduce the immediacy of a risk. The second tenet is quantitative. And so, this is in the way. How much force is needed to achieve the objective, and the level of force should be used to the minimum that can still be considered effective. And so we also don't have a lot of states that really make this explicit in law. As I covered in the earlier slide with the map, just Tennessee and Delaware have in their statute, the deadly force is justified if all of the reasonable options are exhausted. This language isn't precise, but it's similar in both of the statutes. We think it's a step in the right direction. There are obviously other problems with those state statutes, but that particular component hits relatively close to what we believe would represent quantitative. Some other key terms that could be included would be defining if force, if de-escalation is required, or reserving force for after exhausted, and also the incorporation of language. That language is included in some bills this year, as well as an aspect of the George Floyd Justice and Policing Act that Congressman Jeffrey spoke about, the Peace Act, that I'll also get to later. And then the final component of necessity that's worth thinking about too is the use of force must stop once the objective has been achieved or is no longer deemed to be achievable. And so actually just over the summer, Vermont did pass a law that I think hits pretty closely at this. Their law now says that a law enforcement official shall cease the use of deadly force as soon as the subject is under the officer's control and no longer poses an imminent threat of death or serious bodily injury to the officer or another person. And this is the first time I've seen any language like this in a law, and I had nothing to do with it and was thrilled to find it. So I am now working to advise states to incorporate language along these lines because we think it's important to make this point of clarity. I think really the big takeaway from this sort of section of the presentation is that while states may seek to go beyond or supersede the reasonableness standard from Graham to a necessary one, rarely are they actually making clear and transparent what that means. And as of now, there are only a few states that include or sort of have really campaigned for a necessary standard. And so it's not clear as of yet how courts will interpret that to be more restrictive or not. So taking a look at how sort of these things have advanced over some recent improvements, since it's part of my job to work with states to improve their statutory language. Some advancement towards human rights standards, which includes the necessary components, but other things as well. Proportionality is particularly missing from a lot of our use of force statutory laws as well. But in 2018, Washington State, they passed a law. It was a real tussle. It started as a ballot initiative, I-940, and then eventually it was passed by the legislature. Their law included a requirement that officers, there was a proof of malice intent of the officer's actions. So that was removed, which is a huge step, enormous barrier to achieve legally to prove that officers' force was unjustified. In 2019, California made huge inroads. They expanded their use of force statute, which wasn't in compliance with Tennessee versus Garner. So they updated that. They added necessary to their statute, though it's not defined. And they also did something which I view as incredibly important in that Graham versus Connor's concept of totality of the circumstances examines the moment for which force is used. And in California's law, they expanded upon that language by stating, spelling out in it, that the conduct or the actions of the officer and the subject should be examined leading up to and at the moment of the use of force encounter. We think this is really important because it helps provide a bigger perspective of if an officer, in fact, acted in a way that was negligent to cause a need for force. And that really should be taken into account as we understand these events to be justified or not. And then finally, Vermont, as I covered earlier, they incorporated some additional elements with that last piece of temporal and their standard, and they also defined necessary and also provided a definition for proportionality, which I hadn't seen anywhere before. So that's really wonderful too. Just as a heads up of something you can keep track of is right now, as I mentioned, Captain Pruitt and I are hard at work to try to get Maryland to enact statutory limitations to their use of force. The bills that Amnesty are supporting are HB 139, which had a hearing last night, and SB 626. That bill includes a lot of these elements that I've discussed, but I won't belabor that point. In Washington State, while they made progress in 2018, they want to continue to build upon that. I think they're going back and realizing that necessary wasn't really well explained. And so they've added some additional language to provide clarity there and sort of push back on the argument that is often made that you can't, that Graham versus Connor is the law of the land. You can't go beyond that. But as of yet, California hasn't been sued for it. So I'm going to say that you're allowed to build on top of that constitutional floor. And then finally, New Mexico, that's also incorporated some of these international elements and their language. That bill came out, I think, maybe 2 weeks ago. So just getting started there, but states are starting to look more carefully. And I should share that, while Washington, Maryland, and many of these other states had attempts at use of force before, really after the killing of George Floyd, legislatures across the nation decided that it was something they really needed to take a close look at. And we think that's really wonderful. And we hope that we can provide enough research and information so that it's done in a manner that will be impactful to prevent the unnecessary loss of life. And so finally, I'll just talk a bit about it at the national level, since that's a bit of what we work on as well. And sort of what we look to build off of this model that was created from California's AB 392. It's called the Peace Act, and as I noted, is included in the George Floyd Justice and Policing Act. So the Peace Act reserves deadly force unless it's necessary as a last resort to prevent an imminent threat of death or serious bodily injury, and reasonable alternatives have been exhausted. It requires officers to give a verbal warning and de-escalate and encounter before resorting to deadly force. It takes that language from California to build in totality of the circumstances to include that they're leading up to the use of force encounter. It provides a limitation of an officer's defense should they have acted out of negligence to cause a need for such force. And this bill as written also requires the Attorney General to consult with directly impacted people and civil society groups to create guidelines on how to use the least amount of force on sort of vulnerable populations or populations we see largely overrepresented in use of force cases. And so that's something that we continue to work on. We know that the work that's done at the state level helps to build the case for the federal level, and the federal level also helps influence the states. So it's important to really do both at the same time. But that's a bit about what we do. And with that, I'm going to turn it over to Andres.
Thank you very much, Christina. Professor Wood, should I go ahead? Okay, great. Thank you once again, Professor Woods, for having me here. And I really also want to extend a big and heartfelt thank you to President Hoffler for her warm welcome, and especially for supporting events like this that dive into elements as important as the one we're discussing today, and which also make a real effort to incorporate the international perspective. And it's really something that we greatly appreciate. I'll take a moment now to share my presentation with you. So what I was thinking I could do for us today is perhaps begin by talking a little bit, just giving you a little bit of a background as to who we are at OHCHR, what some of the work is that we do that is directly related to issues of use of force and discrimination with regard to people of African descent, and then move us into a discussion on a more technical level of the international norms and standards on the use of force by law enforcement officials. So first, let's talk briefly about the Office of the High Commissioner for Human Rights. We're known as OHCHR for short, and we're essentially the custodian of international human rights law for the United Nations. And we have lead responsibility for promoting and protecting human rights within the United Nations system. And there are three areas of work, if you will, that we really, that I'd wish to highlight for you. The first one is the work done by the High Commissioner and her office. She's the highest official within the United Nations system representing human rights and advocating for human rights. And her office, where I work, is composed of various branches and sections that provide assistance to governments in implementing and fulfilling their obligations under international human rights law. And we also assist with implementing the advocacy of human rights on the ground through around 85 country offices and through a variety of programs that range from technical capacity building, for example, on issues of use of force for security forces and general human rights education. The office also provides support to what we sort of refer to in shorthand as treaty bodies. And here I'm referring to 10 human rights treaty bodies, which are groups of independent experts that are tasked with monitoring the implementation of the core 10 human rights treaties of international human rights law and within the UN. And these are legally binding. And they conduct country visits at times to see what things are like on the ground, to speak to governments, and they also receive and evaluate complaints on behalf of other states and under some circumstances from individuals and organizations as well. OHCHR also provides support to what we refer to as special procedures. And here I'm referring to the work of independent thematic and country experts, be they working groups on particular thematic issues or what's known as special rapporteurs, who are also working on thematic or country issues. the special rapporteurs and the working groups have independent mandates, but we provide research and support and facilitate the work that they do. Now, having sort of given you the backdrop from a bird's eye view of what OHCHR does, let's drill down a little bit and talk about what we are doing or what OHCHR has going in the context of people of African descent. Now, as you can imagine, every human right is applicable to everybody. So all the work we do in one way or another is cross-cutting and relevant to people of African descent. I've highlighted for you, however, 3 distinct groups that are perhaps the ones with the mandates that are most relevant to this issue. We have a working group of experts on people of African descent, and also a special rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. Now, those are 2 examples of the special procedures that I mentioned earlier. Also within the house, or within the office, if you will, in my branch, in fact, there's an anti-racial discrimination section that focuses exclusively on this issue with regard to how it intersects with human rights. Now, this is sort of a discussion of the macro level and the mid-level and the permanent structure that we have in place. But I really want to highlight for you that OHCHR also is enabled and does react on an ad hoc basis to issues of imminent concern. And without a doubt, one of the major ones in front of us today is the issue of use of force and discrimination against people of African descent and the Black community. And when the spate of killings kicked off last summer, it immediately caught the attention of OHCHR, and the High Commissioner issued 4 statements on systemic racism and police violence immediately around that period from May to August 2020, and also in concert with 4 statements by various mandate holders of the special procedures. And I've selected one of these statements for you, and I just want to go into it a bit just to really reflect the seriousness with which we consider this issue. One of those 4 statements was a joint statement by no less than 28 of the special procedures mandate holders. Now, usually we have, it's not uncommon for there to be statements, that, on cross-cutting issues that a couple special procedures mandate holders will talk about, but this one had none less than 28, ranging in everything from, the effect of toxic waste and hazardous waste on the environment, to the use of mercenaries, and then to the obvious ones, like the working group of experts on people of African descent and the special rapporteur on racism and related intolerance. So basically, this really struck to the core of all of us and what we do. And just to talk to you a little bit about what that statement said, it basically was, a ringing indictment of what we saw occurring in the United States over the summer. And it basically condemned the spate of killings of African Americans that occurred last summer, and mentioned by name Ahmaud Arbery, Breonna Taylor, and George Floyd. And I quote, referred to these as modern day racial terror lynchings, given that they involved impunity, particular disregard or depravity towards human life, and the use of public spaces to assert racial control, each characteristic of lynching. And this is something that came out from the special procedures with their independent mandate. And given that the United Nations architecture, really works towards diplomacy and consensus, a lot of times, words are chosen carefully. And in this instance, it was really something that we felt needed to be said, and the special rapporteurs and the special procedures felt they needed to be said in those uncertain terms. Now, the discussion of this issue led to something that's known as an urgent debate, and that's an ad hoc discussion of a thematic issue by the countries in the Human Rights Council. It was addressed by the Human Rights, by the High Commissioner, and it was an urgent debate in June of last year on the issue of police brutality and violence against peaceful protests. And out of that urgent debate and that session of the Human Rights Council arose a resolution, which you can find online, and it's Resolution 43-1. It was adopted unanimously, shall I add, by the 47 countries currently on the Human Rights Council, the ones who were there last year. And it refers specifically to the issue of human rights and fundamental freedoms of Africans and people of African descent globally, again, with specific reference to the case of George Floyd and others similar in the United States, and the use of force and law enforcement. And in response to this resolution, OHCHR is assisting the High Commissioner to prepare a comprehensive report, which goes into this issue, which we hope to release in June. So I would, stay posted for that. And then to also examine government responses to peaceful anti-racism protests, and to provide oral updates on this very issue at every Human Rights Council session. There are 3 per year, indefinitely. So just to underscore the importance with which the human rights architecture in the United Nations is viewing this issue. Now, let's move into a bit more of a technical discussion. And the first thing I'd like to share with you is the legal framework specifically on use of force by law enforcement. So first, let's talk about 2 instruments. Well, actually, they're actually guidance. The Code of Conduct for Law Enforcement Officials, which was adopted by a UN General Assembly. And we also have the Basic Principles on the Use of Force and Firearms by Law Enforcement Officials. Now, these 2 instruments, although not legally binding, they are the sum total of extensive consultation and discussions among member states in the context of the Code of Conduct and in the context of the Basic Principles as a result of discussions between policymakers, law enforcement, academics, civil society, and international organizations. Now, we also issued from OHCHR, or OHCHR participated in the production of 2 very important and seminal guidance documents. One is a resource book on the use of force and firearms by law enforcement officials, which is a joint effort with our strong partner, the UN Office on Drugs and Crime, or UNODC. And also very recently, we have published and issued human rights guidance on the use of less lethal weapons in law enforcement. Now, if I can take a moment to sort of underscore or talk a bit about the last one, if anybody is interested in what we could possibly call a one-stop shop for understanding the basic principles on the use of force, and then going into what would be considered lawful use, unlawful use of less lethal weapons and ammunition, I would strongly recommend taking a look at this document. It distills the basic principles. It's a user-friendly document that is easy to navigate either by an end user in the field who wishes to do an assessment or an organization. And it also provides weapon-specific, scenario-based analyses of how your most common less lethal weapons or munitions are used, for example, everything ranging from batons to water cannon to conducted electrical weapons like tasers and chemical irritants, tear gas, pepper spray, so on and so forth. It's a very valuable resource that we're quite proud to have worked together with the University of Pretoria and also the Geneva Academy, and it will be soon available in all the official UN languages. Now, these instruments and documents and guidance that I've just shared with you, they have the most specific utterances on the use of force by law enforcement. And some of you may ask, well, if they're not legally binding, or in the case of the resource book or the guidance, if they're just guidance documents, how does this look, from the standpoint of somebody who's looking for sort of, to highlight an obligation that states may have? And I'd say here, it's very important to discuss the link between these documents on this slide and the binding legal obligations that states have under international human rights treaties. Essentially, these principles and these standards that are here inform the interpretation of, excuse me, I jumped, there we go. They inform the legal framework on international human rights, which is binding. There are a variety of binding international treaties on human rights, and one of them, one of the most renowned, is the International Covenant on Civil and Political Rights, also known as the ICCPR. And contained within that document, there are 2 very important rights that Chrissy mentioned. One is the right to life, and one is the right to liberty and security of person. Security of person here would refer to injury, either physical or mental, and the right to life, of course, guards against arbitrary deprivation of life. Now, when we look at what is meant by arbitrary deprivation of life and the binding prohibition against this, and I should add the United States is a signatory to the ICCPR, we are talking about a deprivation of life or a killing that is otherwise, that is lacking a legal basis or is otherwise inconsistent with life-protecting laws and procedures. I underline this because we've just discussed what some of these life protecting laws and procedures are, and I'll go back for a bit and talk about the basic principles. In something that is known as a general comment, which is an authoritative interpretation of the different articles of the ICCPR drafted by the Human Rights Committee, we have guidance on how to interpret, for example, the right to life. And there is a general comment called General Comment 36, which refers specifically to the right to life and provides a lot of compass bearings for people who wish to know, what do these obligations look like in practice? And one of the unequivocal statements in that general comment is that all law enforcement operations should comply with international standards, including the Code of Conduct and basic principles on the use of force in firearms, which you discussed earlier. So you can see here the nexus between those standards and now how they inform the norms or the legally binding framework and how they are important for that. The same goes for the right to liberty, which protects against the intentional infliction of bodily or mental injury that is arbitrary. And the general comment, which is 35 for that particular human right, Article 9, says also unequivocally that law enforcement officials violate the right to personal security when they unjustifiably inflict bodily injury. So here we're seeing how, again, the documents that we talked about before are informing and part and parcel of interpreting binding legal obligations on states, including the United States. I should add that one tidbit from General Comment 36 on the right to life indicates that the killing of peaceful protesters is a per se violation of the right to life. I'll go back. I did that leap deliberately so we could really highlight how they're inextricably linked. But let me just take a second to collaborate with Chrissy and sort of add a couple thoughts, if you will, to the discussion of basic principles. Adding to her able description of the principle of necessity, I would also agree that the principle of necessity is extremely important for us to understand. The term excessive use of force, it is a valid term. But if I may, it is most closely linked to the principle of proportionality, which discusses how much force is acceptable in the circumstances. So I would urge all of us, if we are discussing use of force violations or alleged use of force violations generally, if we're assessing a scenario where multiple violations of basic principles, of different principles might be possible, I would urge the room, I would urge the audience to opt for discussing or using the term use of force violations. Because if we talk about excessive use of force, we might not be encompassing violations, for example, of the principle of necessity, which really is about whether force should have been used in the first place. And we see that quite a bit. For example, if a law enforcement officer approaches a peaceful protester and uses force, in that instance, we're looking at a high risk of a violation of the principle of necessity, much more than we're talking about the principle of proportionality and excessive force. Also, I'd like to highlight for you the principle of precaution. That is an upstream principle, if you will, and that's one that is meant to be abided by in the operational planning phase. And what the principle of precaution really does is it, urges law enforcement officials and mentions that they should plan law enforcement operations in a way that would minimize and reduce the risk of use of force or disproportionate force. For example, if law enforcement operations officers are to be deployed to police a protest, we're looking at a risk of violating the principle of precaution if those officers are being deployed exclusively with firearms and lethal ammunition and not with a range of tactics or training that'll allow for a differentiated application of the use of force. I'd also like to highlight for you another basic principle, which is the principle of non-discrimination. This one is obviously extremely relevant to our discussion today, and it can be found in Article 2 of the Code of Conduct. And that principle says that in using force, law enforcement officials should never discriminate on the basis of race, ethnicity, gender, sex, sexual orientation, political views, and a variety of other equally important sort of characteristics. Of course, if law enforcement were to use force exclusively against the Black community in a protest or against people who are in support of, for example, the Black Lives Matter movement, and not apply force equally to other individuals from other groups who might be presenting the same, threats to law enforcement, then that is going to be, we're going to be looking at a possible, quite likely violation of the principle of non-discrimination. I've sort of listed these here for you, top to bottom. I don't have a good mnemonic device like Chrissy does. That was really great. I'll have to remember that. But I've sort of listed them for you in what you could probably consider sort of an operational sequence. Precaution being the first upstream, moving down through legality, in pursuit of a legal law enforcement objective. It would have to be legal under domestic and international law according to our standards. And then necessity, is the force necessary? If so, how much? Proportionality, make sure we don't discriminate. And after the fact, of course, all law enforcement officers are accountable for all use of force. Some discrete points for you on the use of lethal force with a firearm to collaborate further with Chrissy. Article 9 of the basic principles sets forth a bifurcated approach to lethal force with a firearm. There's potentially lethal force, which we consider any use of a firearm that isn't intentional, where the shot placement, if you will, is designed to kill somebody. Even if a law enforcement officer or anybody is using a firearm and firing lethal ammunition, let's say at an extremity or a hand or a foot, or even near somebody, because of the inherent risks that firearms and lethal ammunition pose, that is recognized, and we consider all of that potentially lethal force. And the threshold of conduct by the person being targeted must be imminent threat of death or serious injury. Now, we have a different assessment for intentionally lethal force. That is, the officer is intending to take the life of somebody, and that's something that is only permissible when there's an imminent threat of death. You can see that here we're missing the serious injury component, an imminent threat of death. In the discussion, in Chrissy's discussion, she mentioned the importance of, codifying some of these principles and really making them express. I would, urge anybody working in legal drafting, and I really, turn that eye inwards on ourselves as well, about the importance of defining imminence, because that's a key component of the assessment. And what is imminent for one person might be different for somebody else. And if the consequences, whether to use lethal force or not, I would argue, or we would argue that, really defining this is pretty key. I mean, we have one coordinate within our system, and it's a comment made by the former special rapporteur on extrajudicial killings, summary, and arbitrary executions. And he mentioned that imminence should be considered a split second, or at most a couple seconds. And that's sort of been repeated in our resource book. So that has some weight behind it if you care to take a look at that. And then lastly, I think I have a little bit left. I really want to sort of end this presentation with a call to all of us and express solidarity with the importance of tackling this particular and discrete issue in use of force in law enforcement. It is something that's been around for a while, and we unfortunately see this all throughout the world, starting with the context of like the global protests that were occurring in 2019, all through what happened last summer, the spate of killings of African Americans in the US, and onward into the current day, and that is the misuse of less lethal weapons and ammunition. Less lethal weapons and ammunition are a valuable tool, if you will, for law enforcement to be able to place their use of force on a spectrum, depending on the threat they face, right? So they're something that they actually, their existence enhances in sort of a general sense, the ability to use force proportionally. However, we call them less lethal for a reason. We don't call them non-lethal because, and I'm glad to see us moving in this direction sort of as a community, any one of these weapons, if used outside of less lethal parameters, can kill a person. So just because they're being used doesn't mean everything's okay. And what we see is the fact that either, because there's a lack of training or an unfamiliarity with the weapon, or a weapon that's been, hasn't been vetted, or in some unfortunate instances with deliberate intent, there is use of less lethal weapons and ammunition by law enforcement outside of these less lethal parameters, which end up causing maximum physical damage to individuals. Just because they're being used, it's not like throwing your hazards on when you double park and it kind of makes everything okay. They need to be used properly, and they need to be used within, less lethal parameters and according to international norms and standards. Our guidance on this goes into more detail. And just to leave you with a couple of examples of what I'm referring to, something that you'll see very often, all you have to do is do, some basic open source research or have been at a protest yourself And you will unfortunately see instances where tear gas canisters are fired directly at individuals. They're meant to be fired indirectly, and many times they're aimed at individuals. They're usually accurate depending, on the shape of the canister and the weapon firing it. They're accurate 30 meters, so you can hit somebody with it before it starts to deviate based on sort of, the shape and the aerodynamics. And at close range, they can penetrate rib cages and cause lethal injury. Kinetic impact projectiles like beanbag rounds, rubber bullets, as they're referred to, directed at head, face, or throat, that's a big no-no under the international standards because they can penetrate, they can damage soft tissue, and they can be lethal. And finally, chemical irritants, in enclosed spaces. There are a lot of ways in which, they shouldn't be used, but one that I'd like to highlight is using them in enclosed spaces because that obviously, enhances or, really has an exponential effect on the respiratory system of individuals. And if we're, doing this with a child who is panicking and not breathing properly because they're scared, and then car doors are closed on her with the windows up, then we're looking at, some issues right there that need to be addressed. I'll leave it there. Thank you very much for your attention. I hope I've been able to add something to the discussion. Thank you.
Christina and Andreas, thank you. That was awesome. Very informative. So of course, we're going to start with Captain Pruitt. So we've heard from the congressman. We have an understanding of international law and standards. From the eyes of a Black officer, how does this work? Does it work? Okay. Well, let me ask Chris, please, CK.
I'm not sure if her screen is frozen. Captain
No,
Pruitt?
she can't. She waved. I think there is a technical issue in regards to her mute button.
Okay.
So and I'll ask you, President Hoffler, you stated this is an international human rights issue. Why did you make that proclamation?
Well, because what happens here to African Americans happens everywhere in the world, to Black people, to Black and brown people. And just as we heard from the presentation that both Christina and Andreas did, this is a global issue. It's a global pandemic. So it's a human rights issue. The way that we in a racist, discriminatory way, treat African Americans in terms of excessive use of force is a human rights issue. And it's not just an issue here domestically. If we were to speak to law enforcement or speak to the communities, Black American communities in England, in France, places where there are large people of African descent, communities where there are large numbers of people of African descent, you will see a similar pattern. So it's not just an American issue, but there's solidarity in the international community because it is a human rights concern. How we treat people of African descent in the world is a major problem and has been a problem for a very long time. So when Amnesty International talks about, focuses on some of the standards and the structures and the legal analysis, that analysis can be applied to a number of countries because we see similar patterns. That's why this global discussion is important. At our upcoming conference, Chairman Woods, I'm just forecasting one of the things we need to do, is I'd like to see input from people, from law enforcement in England, from people in England, from people in France, from people in Paris, for instance. We see this as this is a huge issue, I know, because I've looked at this question before in terms of how certain communities are treated. It's just so ironic that for years, the United States has positioned itself as the leader, as the go-to country when it came to issues of democracy, including treatment or excessive use of force. And as we now know, in terms of issues of, and we used ourselves as the role model, if you will, globally for how elections, if we just use elections, should be conducted throughout the world, democratic elections. Well, given what has happened and transpired in the United States of late, there is a different narrative that is being spoken internationally. I think there's also a different narrative in terms of excessive use of force that is being spoken as well. So that's how I like to look at it. And I'd like us to look at the issues that are uncomfortable. That's an uncomfortable discussion. But if we can't have uncomfortable discussions at the National Bar Association, there is no other place to have uncomfortable discussions, because it is our community that's being mostly impacted. So I'm in favor, as you all know, of uncomfortable discussions. And Chairman Woods, we need to be and feel uncomfortable, because the only way that we bring about change is when people feel uncomfortable with the discussions.
Great, that was amazing. Now, just to follow up on that, when we look at this issue, it contains various subcomponents. For example, you have systemic discrimination, which manifests itself through death of unarmed Black people in police custody. And then ultimately, those that peacefully protest are also subjected to force. So I'll start with Christina. Where do you begin in regards to addressing these issues with so many subcomponents?
Well, that's a large question to answer. I'll first start by piggybacking a bit off of what President Hoffler said, in that this is a global issue, truly. And with the killing of George Floyd, having the benefit of working for a global organization, we have sections in, I think, 71 countries around the world. And a lot of them, mostly those that are traditionally made up of Caucasian or European folks, were like, oh my gosh, this issue is huge. We had no idea. And while I was excited that they were eager to learn more and solve the issue and pay attention for this because of the visibility of the killing of George Floyd, I was also quite disappointed, because the reality is George Floyd is a name in a long string of people that have been egregiously killed by police, Black people that have been killed by police in the US. It's been going on since the inception of policing. So it is, at first, the first thing we have to do is acknowledge that this is a problem we have, and it is a problem we have had for a very long time. And that while domestically we have this issue, it also permeates the globe too. And other countries that are sort of founded with similar colonial rulers, even though their law enforcement may be people of African descent, that doesn't mean that there still isn't sort of a overrepresentation of particular populations that are targeted by those law enforcement. We certainly saw our colleagues in Nigeria over the summer really fighting some awful things. And so it has been brought to the public's attention in a very realistic way because of the protests that have taken place in support of Black lives, both here in the US and around the globe, and seeing that force in a really aggressive way used against people who are just expressing their First Amendment rights or their liberties, and experiencing force in a disproportionate way. But it also, of course, happens in the more extreme law enforcement caused deaths. And so the first step is acknowledging we have a problem that needs to be addressed, and it ranges. And another piece that we have to take into consideration how we want to address these changes that are required or necessary for law enforcement is that when we see law enforcement commit these sort of violations, it's often true that they also are violating other rules and regulations within sort of policing policies, right? Like the same officers that have a record of killing people also probably are breaking other rules on a much less lethal scale, right? They have issues with sort of like discriminatory stops or other sort of things. And so the first step is really that we acknowledge the visibility and education of the issue. The second step is that we require that transparency be a core component to expose this issue so that people know about it from our governments themselves. You know, it's a shame that in the US, the primary way to learn about people that are killed by police is through sort of news agencies that provide that information. Our laws require it. Our Department of Justice has never enacted or really implemented the Death in Custody Reporting Act. And so this information is not available or government provided information. And then of course, the final step is really working towards accountability through really limiting the use of force by law enforcement, we believe, but that's really just one component of it. There are lots of other things and other parts of the laws that should change as well. We may react strongly to seeing images of people being killed or tortured through chokeholds, but there are all kinds of other things that need to change, stronger protections in the non-discrimination lane, and really also addressing qualified immunity and what that means for barriers for truly gaining accountability when law enforcement transgress someone's civil rights and civil liberties, constitutional rights, I should say. So I'll stop there.
Very good, appreciate that. Andreas, if you could contribute, there was discussion in regards to use of force from a standard perspective versus how that's applied or not applied in the United States. Is that a global issue in regards to the implementation or application of use of force statutes to comply with standards?
Thanks, John. Yeah, I mean, I think we're definitely looking at an issue that is global in nature. You know, we see a lot of the same patterns, unfortunately, across the globe, really in all regions. And it is a challenge, isn't it, for you know, these principles, which are so valuable and should be followed, to be implemented properly. At times it's a challenge because there's a lack of training, perhaps. There's a lack of understanding of what they mean. There's a lack of resources, either financially or, you know, which translates into actual kit that is necessary to do it. And you know, operationally, sometimes things can be really complicated. It doesn't mean that that excuses inappropriate use of force, but it's just important for us, I think, as we have alluded here, to just acknowledge that, you know, it's something that's really, that, you know, it's a really tricky thing to do right. It should be done right by all means, but because it's so tricky, we should be investing a lot of time and effort into ensuring that the women and men of law enforcement are fully trained and capacitated and resourced to do this properly. And in addition, there needs to be a legal framework, as you alluded to, and as Chrissy alluded to, there needs to be a legal framework that reflects all of this, because without that, we don't have compass bearings. You know, we just sort of have fears, we have biases, we have, you know, misunderstandings of when we should be shooting somebody or not. And we all need a map, you know, and you know, that is really, you've highlighted a real gulf there. And I think translating things into easily understandable legislation that is not vague or overly broad or inconsistent it's something that's within our reach. Absolutely. You know, we have a lot of dedicated legal professionals out there and organizations who can feed into this process, but, you know, we're not there yet. You know, one sort of disconnect that we see oftentimes in legislation globally is, you know, which operationally you see, you know, the connection is when military personnel, you know, comes onto the court to assist in law enforcement operations. First of all, that should always be an extremely exceptional measure. There's an understanding that there are circumstances where it has to happen, but it's meant to be an extremely exceptional measure. But when there are grounds for doing this, the basic principles in the code of conduct are clear. Military personnel assisting in a law enforcement operation is subject to the international norms and standards for law enforcement personnel and not for armed conflict. I think even Congressman Jeffries mentioned that, didn't he? He mentioned, you know, sometimes it feels like we're interacting with individuals as enemy combatants, and that's precisely a problem because the rules of engagement are different. They're very different. And in the law enforcement paradigm, you know, we have different, you know, standards for when lethal force can be applied or not and how we perceive people. But what we see, going back to your point on legislation, is oftentimes there are two separate worlds in legislation. And you have the armed forces abiding by their code, which makes sense and is there for them in the context they normally find themselves in, which is armed conflict. But then when they're called in to help, that's what they think that they need to be abiding by. And so then you see a disconnect on the ground where you have, in an ideal case, a law enforcement officer, you know, thinking about the basic principles, but then you might have military personnel reacting very quickly and very decisively against people because they're trained to do that in the battlefield. So that is a big disconnect, and we need sort of that bridging legislation, if you will. Thank you.
Oh, thank you. Captain Pruitt, how we doing?
You know, sometimes the devil just don't want me to talk. I mean, the timing of that just, my computer just went on the fritz. Okay, I'm back, y'all. And so thank you again for having me. you know, I love conversations where I learn, where I'm not just talking. So as everyone was speaking, I was taking notes because I like to be able to use my vantage point to bring the conversation together as a law enforcer or previous law enforcer. I don't even like using that term law enforcer. It's just too harsh for me now, but I think you all know what I mean. So here's the things that I was thinking of as everyone was speaking, as Chrissy and Andres was laying it down, and you guys are so awesome. I'm just like, wow. So I do work with my peers in other countries like South Africa, Ireland, the UK, Canada, the Caribbean, I mean, all over the world. And it's always amazing to me that we all have the same conversations, no matter what part of the world we are from, especially as it concerns use of force of police officers in these countries. And so let me just tell you what I wrote down and just expand on it just a little bit. Chrissy, you brought the pain with the whole necessity conversation. You know, in the United States, there's just no consistency. There's no consistency concerning what reasonableness is. Like, what is that? Reasonable to who? To all officers, to the officer on the scene? And that's actually used against the community, because what ends up happening is there's this an incident occurs, someone is injured or killed, a citizen, and the police immediately go to, well, what was reasonable? And then the conversation moves to what was justified. So Andres, when you talked about, oh, let me just put my glasses on so I can see. I'm so excited about this conversation. You talked about the right to liberty and security of person. And it mentions unjustifiably inflicting bodily injury. So what is justify? In the United States, justify is a huge, wide range of things to the police. And immediately after an incident, you will hear, well, they were justified, but nobody wants to talk about, was it necessary? Justified does not mean necessary. So it is really crucial that we continue to move forward in this conversation about what necessariness is and what is the necessity of using this force. Do you need to use force? How much force is actually needed? And why don't you stop when you don't need the force anymore? Those things are captured in policy in the United States. Those things are captured in policy in different police departments. And I promise you that it looks different in each policy manual. So again, we have no consistency about how we are approaching the use of force in the United States. I wanted to point something out. There are moments in police history that are really critical, and they're always involving use of force. For instance, I'm not going to go back too far. I'm going to just go back to like 1992, 94. Rodney King. We had the Rodney King incident, and right after the Rodney King incident, there was a focus on use of force. And what happened? You know, a couple of people put together a commission and they had a task force. They talked about use of force, and then nothing changed, right? So we fast forward and we have the Michael Brown incident in the early 2000s. What happened then? That was the advent of the focus on body cameras. So now we have body cameras and we can see what people are doing, right? And guess what happened in terms of the actual interaction with police? Nothing has actually changed. Now we can just see it happening, but people don't want to believe their lying eyes, right? Then we have the George Floyd incident. And that seems to have been like the one to us that is like, oh my God, now we're going to really focus in on this use of force. And we see, at least I'm going to speak for Chrissy and I. We can when we testify in the Maryland legislature, and we see law enforcement pushing back on us making these reforms in the area of use of force, and it's disappointing because it's because of the culture of policing and this whole blue thing. And, you know, we're a fraternity. By the way, women are really not included in that fraternity. We're a fraternity, we're one, we're a monolith, we all think alike. That is not true. That is not true. And so we are stuck. And in particular, police leadership is stuck talking about wanting police reform after the death of George Floyd, when Officer Chauvin put his knee on the neck of a man until he died. You saw police officers with their fist in the air and they were kneeling and they were like, oh, we're one with the Black Lives Matter movement. And then 2 weeks later, the union said, you better get up off your knees and get back to work or we're not going to represent you. And police leadership was like, yeah, well, yeah, y'all better get up off your knees. The response for me from police leadership has been lukewarm. So we have to push this effort through pushing for, you're not going to get your money for your police department. You're not going to get paid, whatever we have to do to make it work. So here's the last thing I'm going to say from my notes. We talk about use of force as being a thing that affects the ability for citizens and Black people in particular in the US to just live a normal life. I like to look at it more holistically. President Hoffler made a comment when I was introduced about it's important for officers on the inside and after the retirement on the outside to speak up on these issues. I have to tell you that on the inside, there is a use of force against Black officers. So that same thing that allows an officer to go out and to beat a Rodney King or to kill a Michael Brown or to murder a George Floyd is the same thing that allows officers to discriminate and beat on us as Black officers on the inside. So when people ask the question, well, where are the Black officers? What are they doing? They're on the inside being traumatized and trying to survive. And so that is why you may not hear very many say anything while they are active. We have to wait until we're retired. And see, what I did was I said, I'm going to learn everything I can about this police department. And when I leave, I'm going to let people know exactly how it works, because if you don't know that, then you can't make the change. Thank you.
Thank you. Thank you. I didn't want you to stop. So I have a follow-up question for Captain Pruitt and also Christina. So you mentioned in your presentation, Christina, that use of force, there's no compliance with international law and standards, and only 9 states have no use of force law. Where is the resistance? What is the resistance in regards to this area from a policy perspective?
Well, I think it's a number of things. You know, I have at this point now sort of gotten my hands in a couple of the sort of state legislative processes about pushing for limitations to the use of force. And Maryland is my first endeavor with a state that just doesn't have a law at all. Others had a law, they have a law, it's just not good enough, which none of them are by our standards. But the resistance is a number of things, and in that, you know, law enforcement, and I will of course let Captain Pruitt really represent that voice, but some of the pushback I hear from law enforcement is about making sure that the laws allow them to actually do their job. They feel like some of these laws are so limited, they're not even gonna be able to get out of the car or interact with people, or that they put their own lives at risk. Another argument we hear that we heard in Maryland a couple of weeks ago is, I was actually quite surprised that the law enforcement felt like, who testified against this bill that we're supporting, they didn't actually challenge so much about the language of the bill, but they just felt as though having this language as a department policy as opposed to in Maryland statute was a better way to address it. And that is often the case, is that they say like, well, yeah, this is very detailed. This should just be a policy. We should have a uniform policy in the state, because that's not the case in any state. To my understanding is that each department creates their own policy. They also, though, have the ability to change those policies all on their own without the legislature. And so I think I a little bit call bullshit when I hear that, and that, you know, they could choose to change them if they would like. They don't need any permission from me or the public to do that. They don't even all necessarily have their policies available for the public's consumption. So that's another piece of pushback. Occasionally, we also see challenges, particularly with regard to Graham versus Connor, and trying to sort of build upon that constitutional floor set. I've also had coalition partners say like, well, you can't do that. And like, well, we won't know until we try. So we have to do something to try to save people's lives. So on the use of force piece, those are important. But there are certainly, and I'm going to acknowledge a question I saw in the Q&A, you know, what sort of other barriers and limitations are there? And yeah, police unions are a huge problem, right? The primary folks that testify in opposition to these limitations to use of force are the police unions, and they usually sing a pretty similar song. And Graham versus Connor is a big one, like, well, that's the law of the land, and that's that. We just can't do more than that, sorry. But there are other legislative efforts to try to reform what these union contracts look like. I'll admit it's not something I am deeply engaged with, but I do have partners that certainly are looking to do that. And in Maryland, they're trying to sort of repeal and replace a law enforcement officer's Bill of Rights. Those contracts may have rules in them that prevent access to body camera footage for like X amount of days, or give officers time to sort of think about it before they respond to inquiries. I was reminded last night by a member of the public, strong advocate in Maryland, Marion Gray Hopkins, who's the mother of a son who was killed by police in the 90s, that, you know, her son's friends didn't get any time to figure out what their stories were when they were interrogated by the police that night, when they were there when her son Gary was shot and killed. So why is it fair that law enforcement have like several days to respond to some of these questions? And so the union contracts themselves pose a lot of problems. And I do know there are law enforcement and former law enforcement officers like Officer Pruitt, or excuse me, Captain Pruitt, that are working to try to change some of these things. But I think while comprehensive reform is still elusive at the federal level, and states have tried it in a piecemeal perspective, there's so many things that really need to change for us to truly see what is necessary and meaningful. That it's absolutely true that communities of color, particularly Black communities, are overrepresented in those people that are killed and experience excessive and the incorrect use force by police. And like, that's not going to change until people care about it and decide that the laws need to. There are cultural things that need to change that the law can probably never touch. It will truly take changes from the inside in order for that to happen. And, you know, I can tinker all I want with various pieces of the law to try to change that, but I'm not really sure what we can do. But I think it's very clear that, you know, when we bring these matters to congressional offices and say like, why aren't we moving this bill yet? This is important. You know, like, people are getting killed every day. So today is as good a day as any day for you to care about this, because people continue to die at the hands of law enforcement in egregious ways. You know, it's difficult to push. We are seeing a really important moment because of the killing of George Floyd, but and I hope that we can get important and meaningful results. But we really I want to acknowledge that what advocates in the civil and human rights community are asking for has evolved dramatically just over that summer, because of how much sort of like access, or how much legislators were invested in this issue in the first place, right? For years, we've just been asking for like non-discrimination, transparency kind of things as like the big thing, and they hold hearings and take no votes on it. And last year we were like, actually, here's like 8 things we want you to do. You got to do all 8 of these things. And, you know, the voices and the calls from the ground about like, let's defund the police, right? There's a very legitimate call to acknowledge that the monies that go towards law enforcement should better be invested in other services that serve the community, particularly for those that experience sort of trauma and abuse at the hands of police repeatedly. And that like, their limitations to the law might help, but they're better served by responders that might not be, you know, authorized to use deadly force in some situations. And so I'm curious to see what Captain Pruitt has to say about that.
I am as well.
Oh. Okay, so here's my thoughts on that. What Chrissy started off with officers saying that trying to codify this whole police reform piece and use of force and qualified immunity, everything that we're talking about, that it makes it harder to do the job. I don't, you know, I can't relate to that. I like rules and parameters. It makes it easier for me to do my job. If you think about what they're really saying, we don't want you to take away our power. You know, we know that there is a power inequity. The police have a huge amount of power to take freedom, to take a life, to give you a criminal history. That is really what officers are holding on to, because they've been sold this blue dream. Okay, that you come here and, you know, you get to be, some people come to policing because they want to help people. There are other people who come to policing, I am sure, because they can feel this power and we're going to do what we want to do and nobody's going to stop us. If you don't think that those conversations are not being had, absolutely being had. The traditions of policing are passed down. They may be passed down behind closed doors. But you know what you're getting into most of the time when you enter policing. My father was an officer. I knew that I would have an enormous amount of power. And what was I going to do with it? That was my choice. Okay. Here's the thing about policy and training. Policy, I have a friend, he always says policy and training are eaten for breakfast by blue culture. So you can have all the policy you want. If you're not following the policy, if no one is holding you accountable to the policy, what does that mean? Why even have the policy if you're not going to have anyone abide by it? That is why officers, that Chrissy, when we hear the pushback and when we're testifying, they're talking about holding on to me having control as a police leader as to whether or not I even want to hold someone accountable to this policy. And then there's the training piece. Okay, so people only absorb the training that they like. So when we talk about, for instance, diversity training or implicit bias training, if you don't believe in that stuff, really, you're just going to sit in a seat and take up 8 hours, and then you're going to go back in the street and you're going to do all the things that you've always normally done. So the real value in policy is only if you are going to hold officers to policy. That is the only value to it. Otherwise, it means, to me, it just doesn't mean a whole lot. Okay, it depends on your leadership. Police unions. So I love the idea of police unions for things like my wonderful retirement benefits that I have. I have great health care, you know, all the other wonderful things that I left at the police department. Now I'm taking care of, you know, there was the union that made that happen. Uniforms, bargaining for the hours that officers work, overtime issues, those things are pertinent. But the overreach when they become involved in politics, when they do things like, well, we're not going to represent this officer because, you know, they're Black. Let's just put it out there. Or she's a Latina woman. That's discrimination, right? That's bias. And they get away with it. So we talked about the LEOBR in Maryland Law Enforcement Officers Bill of Rights yesterday, Chrissy. I did not get to testify on this. Oof, I could have just testified on this piece about when the FOP president or vice president, Mr. Boatwright, came on and talked about the LEOBR being created to protect Black officers in 1974 from discrimination. I want to say that's a damn lie. Let me tell you what really happened. Black officers were barely making it in 1970s. They had to sue their police departments and their unions for lack of representation. They sued the police departments for discrimination, and because they were not getting promoted, because they could not get nice assignments, and they weren't even getting hired, and they were getting fired. And so the LEOBR did not protect Black officers. It will only protect Black officers if the union decides to represent them. But the general public does not know those things. And so this whole piece about training and policy and the unions, yes, we need to focus on that, but we need to have some real talk about it. And you're probably not going to get a whole lot of active law enforcement who are leaders actually wanting to tell you those things.
Thank you. So Please.
I just have a question in terms of that. I'm just kind of piggybacking on what Captain Pruitt is saying, because we've heard a lot of talk about defunding the police. You know, there's been, and I think, you know, Christina, you talked about that, defunding the police, which I don't know if that's a correct terminology, because that could be something that could be damaging as well. But what I'd like us to consider is how we can be advocates for providing additional resources for mental health and other community resources, because we do need the police to protect, to serve and protect, but there's got to be greater collaboration with the mental health community. But if we talk about defunding, you know, people get very nervous about that, because we're not saying we don't need law enforcement. We just need them to do better. We need greater collaboration with mental health. And I think that that's a discussion I'd also like to have, because these are sensitive issues. When we talk about solutions in our community, we have to really look at some. Again, I'm interested in the difficult discussions, right? The tough discussions. I think that's something that we need to, you know, Chairman Woods, we need to talk about. Mental health issues. How do we expand and increase the funding to incorporate these things that are vitally important to our community?
Thank you, Madam President. What we're going to do now, Tria Harris and Kayla Strauss are Howard Law students that have been working with us. They have captured some of the questions from the general public that's watching, and we appreciate that. So Tria and Kayla, the floor is yours.
Good afternoon, everyone. Thank you so much for having us, and it's been an incredible discussion. I'm going to pull a question to pose for the panelists that came in from the Q&A chat. The first question poses the question, do you believe the biggest obstacle to legislative reform is lobbying efforts by police unions and other similarly minded groups that may want to maintain the status quo? I know you touched on that before, but there's also the follow-up question that says, if so, are there methods by which to incorporate these groups into arriving at a common understanding and have a collective approach to legislating reform for the betterment of policing in the United States?
I'll take that one first. So I would say one of the issues we really saw in California with the passage of AB 392, it was a multi-year effort, pretty traditional, but the law enforcement unions had not only a tremendous amount of power. I don't mean that, of course, they testified in opposition. That's part of their job, where they believe the laws or the bill should be changed or fixed, replaced, or whatever. And eventually what really led to the passage of that law is sort of folks coming to the table on both sides to say, like, what can we live with? What makes sense, right? Is it does take some sort of common understanding and cooperation, but the reality is law enforcement unions also have like sort of a political role in that they make contributions to politicians' campaigns. And not all politicians choose to tell the public about that, how much money they accept from various law enforcement unions. And while I very much respect, as also a union member through my employment at Amnesty International, the unions play a very important role in us receiving standard protections as employees, that sometimes what law enforcement unions do lobby in a way that really doesn't fit with the sort of message of wanting to, you know, address the idea that there is a lack of trust in the community and that they want to regain that trust through community-oriented policing, right? And that those two things are in conflict. And so I do think the unions are an issue. And I think that a way that politicians can choose to address that is at least be transparent about whether or not they're accepting those funds, and if that's, you know, playing some kind of a role in their influence and understanding of how they are voting and relating to these policies. Obviously, law enforcement need to be at the table when we're creating laws that are limiting laws about how they can do their job. That's of course fair and reasonable, but there are other factors that are not at the forefront that should be made visible.
And I have absolutely nothing to add. That was a perfect answer.
All right, next question.
Thank you for that. Thank you again, Professor Woods, for allowing us to have this discussion and for bringing in some Howard students. We're really happy to be here. Our next question is from one of our attendees. Is the international community considering asylum measures or refugee status for Black Americans? This seems to be something that was brought up in the news. So whoever would like to answer, please feel free.
It might be me again. Well, it's not the area that I oversee at Amnesty International, but obviously I do have colleagues that work on our refugee and asylum work. And it is something I believe that is in consideration. Certainly there is a diverse community of organizations that work on, from the advocacy perspective or civil society perspective, not just on the cases. For example, we see a lot of the news focused on folks that are seeking asylum from Latin American countries, but that may not be of African descent, but there are also groups that are really particularly focused on folks of African descent that are coming to the US and making sure that there is an opportunity for that as well, that the policy includes them or that they have protected status if necessary. So it is something folks are working on, and I'd have to check with colleagues to give you much more detail on it, regrettably.
Andreas, did you want to, please?
Thanks. Just briefly, I think that second, they're both excellent questions. On the second one, those issues, they're live issues. They're not really in my wheelhouse, so I'm afraid I can't provide an answer to that. I will sort of just echo what Chrissy said, that there are organizations out there that work on this more specifically, you know, for like UNHCR and so on and so forth. If you'll forgive me for stepping back just a second onto that first question, just very briefly, something came to mind. Although I don't have eyes necessarily on how the police unions specifically are, you know, obstructing or not the process of legislative reform in the US, one thing I did want to share with the room is that oftentimes we find that part of the rift between the human rights community and the reform community and law enforcement is founded on the idea that use of force legislation is inevitably going to reduce the effectiveness of law enforcement and or make it harder for them to make it home at the end of the day or do their job or so on and so forth. There's a sense that there's a hand tying component to this. And I think it's really important for us to deconstruct that, because, you know, poorly written legislation that doesn't incorporate the view of law enforcement or the view of civil society or whatnot can have that effect. But if we look at what we have today in the basic principles that we discussed, if we look at the core of those principles, nowhere in there is there a statement categorically prohibiting use of force or lethal force for that matter. It simply establishes a sort of framework within which it can be used and should be used appropriately to respect human rights and, you know, only come to the fore when it's necessary or proportional or so on and so forth. I think a lot of times, you know, there are a lot of, you know, ideas that are tacked onto the basic principles that if we sort of let them run freely, could sort of fall into the realm of something that makes a law enforcement officer. I think so, you know, Captain Pruitt can speak to this more than I can. I've never worn a uniform, but they can sort of seem overwhelming and maybe sort of, how is this possible on the streets? But in reality, like if you look at the core principles, I would offer that they are very good at establishing sliding scales and leaving the door open for the use of force when it's necessary. We don't usually talk about these principles in the context through the lens of what they allow you to do, but we have to look at that as well, because otherwise we are sort of only framing it as a prohibition. But we need to sort of deconstruct this idea that use of force reform is about not using force. It's about using it appropriately. I think if we're able to somehow get that message across, I'd hope to think that would sort of, you know, maybe, you know, bring down a notch the sort of reaction to these efforts.
Thank you for that. Next question.
Yes, thank you. We have another question from an attendee. It is for Captain Pruitt. They ask, what are your views on reviewing and purging the extremist bad apples from law enforcement via a staggered pause, as seen with the recent announcements by the Secretary of Defense? Is that a viable solution from the law enforcement perspective? And then they reference your comment that you made about intolerant officers remaining intolerant, whether they are enforced to endure diversity training or not.
Wow, I don't know if it was a she, I'm sorry. He or she just like struck me in my heart when you talk about that. Listen, you know, let me see, where do I begin? Black officers have known for so long about the supremacists and the nationalists and the extreme way of thinking. It's the basis of policing, right from the advent of slave patrols. I talked earlier about the traditions coming forward. It's just part of policing. It's not an acceptable part, though. That is why, you know, President Hoffler, you talked about defunding. I'm going to take defunding, and I'm also going to talk about abolishing. That is why the police reform community is talking about defunding and abolishing. And while people don't like the word defunding, just know that defunding has been going on since time untold of police departments. Every time they take some police department money and do something else with it, that's defunding. So I like to take the energy off that word. I do believe in taking our resources and putting them in other places as law enforcement. Okay. But let's get back to this question about supremacy. So we know that these people exist. Black officers have been complaining about it. We've been getting beat upside the head by it. I can tell you story after story after story after story, not only my own stories about discrimination and having been called the N word and the B word and having lies told and knives put in my back as I, you know, went. We can tell you all those stories. It's another call. That's a great call to have. We know that they are there, but the question becomes, why are they still there? They're part of the fabric of policing. So what do we do to get rid of it? I don't believe in no pausing. I believe we should step on the gas on this one, okay? I believe we should put all our resources inside finding out who they are and purging our police departments and then not hiring them, okay? I was on the Prince George's County, Maryland Task Force for Police Reform. The question was asked, well, what kind of tools do you use when you hire officers for the psychological exam? And I was disturbed when I realized, I knew this, but when I realized nothing was probably going to be done about the fact that we don't just ask officers, are you part of a white supremacist group? Or when they come into the door, ask them that question. What do you believe in? You believe in Nazism? I mean, you believe in Hitler? Why can't we ask those questions? Because what happens is if they lie about it and they get hired, then they can get fired easily, right? A couple of years ago, it was found out that officers were on social media in all of these groups. We saw January 6th. I mean, come on, we have all the proof that we need. Again, the question becomes, why are we not doing about it? Why aren't the police departments in the DMV district, Maryland, Virginia, everyone holding an investigation to find out who was at the Capitol? That is the real question. Why not? I don't have an answer to that question. I have all kinds of theories. But if we do not do something about it, we're going to keep going down this road where people are going to die. People of color are going to die at the hands of police because it's part of the power inequity that attracts supremacists and, you know, nationalists to policing because they know they can do what they want to and pretty much get away with it.
Thank you for that response. Next question.
Our next question in the chat is centered around international law perspective. So from an international law perspective, given the current legislative structure in the United States does not mirror international norms on policing, at what point do these issues rise to the level of international scrutiny, whether it be through UN resolutions or other mechanisms, and what can be done?
I can jump in here if you'd like, Kayla. Well, certainly, you know, you've got the domestic legal framework, which is obviously legally binding, but you also have that international legal framework that is legally binding, which I sort of mentioned in the presentation. And that concerns, the treaty obligations of the US as a signatory to a variety of core human rights instruments, many of which contain provisions that stand to be violated if force is used inappropriately. Going back to the ICCPR, the right to life again, the right to security of person, and the right to liberty of person, to personal liberty, which, speaks against arbitrary detention and cautions and works against things like disappearances. Those are binding legal obligations that the US has signed up to. And, there are many ways in which individuals and organizations can raise complaints with human rights treaty bodies. There are 8 of them, which currently under certain circumstances can receive individual complaints. And also the special procedures like the special rapporteurs and the working groups can also receive individual complaints in certain circumstances. And they very often will take an issue that may not be addressed at the national level through domestic legislation for the reasons you mentioned, a lack of mirroring of legislation, a lack of will. And they'll bring it to the international stage and speak out against it. Many times, on the international stage, a lot of times the leverage that will bring, can result in change. I mean, also when there are country visits, for example, some of the special procedures have visited the United States. And in addition, right now, the Universal Periodic Review, which is a sort of a review of states by other states, and there are recommendations that come through this process with regard to use of force and policing. A lot of those, apparently, and from what I've heard, I stand to be corrected, but a lot of those look like they might be incorporated by the new administration in the United States, following the latest round of the UPR and the US. So there are ways to, to bring this to light and to sort of, have the teeth of legally binding obligations, have an effect.
Thank you. Chrissy, did you want to add to that? Okay, we're good. Next question.
Absolutely. I have a question just regarding your thoughts on implementing policy decisions at the community level to help lower the rates of excess force and specifically police brutality. There's been measures that have been suggested, such as requiring police officers to live in the communities such as that they police, as well as requiring individual stations to have liability insurance on officers. So I wanted to get your thoughts on what those kind of measures and what those policies would look like and if they would be effective.
I thought you were reaching for your buttons there, Chrissy. So I think that, there's this guy, his name is Sir Robert Peel. He's considered the father of modern policing. In the 1800s, he created the bobbies in the UK. And Mr. Peel had a set of 9 ethical principles. My favorite one is principle number 2. And although I won't tell you what it is in its entirety because it's kind of long, what he actually says is the police are the people and the people are the police. In other words, there is nothing that our police department should be doing without the public saying, this is what we want. The first part of your question, I was thinking about civilian oversight groups, for instance. There are many in this country, and there are many that are going to be formed. What might be lacking for them is the power to hold officers accountable. So we don't want civilian oversight groups that are just going to be like, here's our opinion, and then the opinion is thrown in the trash can. They should actually be given some power to make change, as to how policy looks, to be able to make sure that those policies are being implemented, which is what we're lacking in now, that accountability piece. Qualified immunity is what you were talking about in the second part. Why are officers being protected? That's another webinar, I think, doctors and President. Why are officers being protected? How come they don't have to pay out of their pockets? Well, that's another piece to be tackled, the whole qualified immunity piece. Maryland is tackling it right now, or at least trying to. And so I do think that it would be valuable if there was some skin in the game for officers. They knew that if this happens, because we're going to have to change paradigms and ways of thinking. And if they knew that, oh, they might be digging into my pocket, my family might be affected, then certainly they will maybe take a quick half-second thought before they do something that they should not. Andres, earlier you talked about, and Christy also, about making split-second decisions. You didn't actually say that, but that's what I heard. And, that's that whole part of training. How are we trained as law enforcement? I'm still talking about qualified immunity, but I just want you to think about the whole training piece, and how, somebody may say, well, an officer has to make split seconds. How's he going to be held liable for making a split second decision? Well, training. Law enforcement are trained that you go home, officer. You do everything you can to make sure you get home to your loved ones and your family. Law enforcement is not trained to make sure everybody goes home. And that's a generalization. But the focus is on the officer going home. The focus is on the humanity of the officer, the protection of the officer, not the protection of citizens, not, the humanity of people, which makes it easy to objectify a person and then use lethal force on them. But if they were made to rethink that, because now we're going to make you pay, then maybe we got something there.
I have a follow-up question that was posed. This is, and some of you may know that in the Florida legislature, the Florida legislature has proposed a bill that would allow a citizen to object if a municipality reduces the law enforcement budget. So the issue would go to the governor, and his decision, or her decision, but in Florida, his decision would be final. What, if anything, can we do about this? And is this also an issue in other states? Can any of the panelists comment on that?
I'll give it a go. I have not heard of that, so thanks for bringing that to my attention. I imagine it's an act of legislation that a legislation would have to be passed in order to give someone the ability to object about a reduction in a police budget. And so surely there are ways for the community to rally against the passage of that legislation is my initial thinking, but it's not something I've seen as a pattern. I know Florida had sort of an outsized reaction as well to the way that police responded to largely peaceful protesters, and that they looked to sort of almost criminalize people who were participating in those protests, and really make it easier to detain, bring those people in for pretrial detention, pending any potential criminal charges. And so that's something that Amnesty did fight against. And I think it was tabled and sort of put on hold, but Florida's not necessarily the state, at least in this regard, that I look for standards. So I'm gonna look further into that, but my initial thinking is just, there's an opportunity for members of the public to fight against that legislation, but it would seem unique to me that one person's protest against a reduction budget would be sufficient to stop such an action.
Thank you. One more question.
Thank you for that. Our next question is centered around the international perspective. So has the international community, from an outsider looking in perspective, seen any similarities or correlations between over-policing and gun control? Also, what about the correlations between police brutality and racial discriminations?
Thanks, Kella. Well, the answer to that is yes. And in fact, one of the areas that I work on, as I mentioned, is the impact or the sort of intersectionality between weapons and human rights. And one of the sort of areas of that focus is civilian acquisition, possession, and use of firearms. And one thing we've seen in the reports of the High Commissioner that we've been putting out, a few of which I've drafted, is that certainly, I think the prevalence of firearms within the community is something that increases the risk of violence, and it's one of the things that sort of facilitates the commission of violence among members of communities. And, you know, in tandem with that, and sort of going back to an earlier question about community policing, we've seen in this, looking worldwide at this issue of civilian acquisition, possession, and use, is that, you know, the holistic approach, if you will, the one that involves social and economic interventions with, you know, communities that are disenfranchised and communities that have issues related to policing, yields very positive results compared to just strictly responding with, you know, exclusively legislation or kinetic responses to threats. And it's something that kind of in a sense mirrors what you see in the context of peace and security worldwide. And that is that if we sort of get at the root cause, to call it that, which is something that happens much more easily through community policing and, you know, these interventions geared at, you know, the root causes of the problem, you know, we see more results. And, you know, I'm sort of searching out a quote for everybody here that related to something the High Commissioner mentioned, but essentially the High Commissioner mentioned, and I can sort of share that with the group later, recently, that, you know, the issue of police violence in the United States recently, and that sort of spate of killings that we sort of saw, or that kind of brought the issue to the fore last summer, in many ways reflects the issue of gun control in the United States, and the two are inextricably linked. And that's something that was made, that's a statement that was made by, you know, the spokesperson for the High Commissioner. And so, yes, and, you know, I think we've all alluded to, certainly racial discrimination and policing, those two intersect oftentimes in terrible ways that lead to use of force violations and human rights violations.
Thank you. Panelists, you were amazing. We truly appreciate your time, effort, and talents. I think President Hoffler will agree with us. This is probably this is probably one of our more informative panel discussions. I feel smarter because of you, and hopefully through this collective effort, we can contribute to some of your individual causes, and you can do the same for us. And we'll talk about that in detail. President Hoffler, last word if you elect.
Yes, well, absolutely. First, I'd like to just make a few comments about the takeaways and thank again the extraordinary panelists from, and thank Chairman Woods for putting together this panel. We want to salute you for all of your work. Christina Roth from Amnesty International, Andreas Perez from the UN, for our students, Kayla and Sonia, for your input. I'm not Sonia, Kayla, Captain Pruitt, but we can call you a student too, because you look just so young. See, that's what it is, but we thank you, Captain Pruitt, for your work. I think it's Trey Harris and Kayla Strauss, we thank you. When we see students, we get excited because you all are the future. And so we're very excited by your contribution. What I'd like to say is that Congressman Hakeem Jeffries set the table for this discussion. He said something that I want us to use as a takeaway. We are going to pass the George Floyd Justice and Policing Act. I think that's what I heard him say. And so I want us to remember that, because we heard it here first at the National Bar Association panel. Secondly, I wanted to recognize just a few people that must be recognized from, we've got two past presidents who have tuned in. That would be past President and Senator Arthena Joyner from Florida, past President Joe Drayton as well. We have former Justice of the Florida Supreme Court, the only Black woman to serve on the Florida Supreme Court, and the only Black woman to serve as Chief Justice, and that would be Justice Peggy Quince. We also have Judge June McKinney, and I see the chair of the YLD section, Onika Williams, and the chair of the Veterans Affairs and Military section, Jamie Boston. I may have missed other people. I just started to look at the attendance, and I just want to thank everyone. This has been the precursor to our international conference that will take place in May. And I just wanted to say again, I want to share two quick experiences with you. I have been, when I was a lawyer, when I was representing the Gabonese Republic many, many years ago, I was working on a white collar case, and I was in Gabon, and I was held up at gunpoint by men with Uzis, because the approach that we used as lawyers was not appreciated, because some of the people allegedly involved in this white collar case, a corruption case, were law enforcement or senior military officials. So that was my experience in 1994. But I can tell you, as scary as that experience was for me personally, and I lived to talk about it. And at another time, I'll tell you the full story because it is kind of funny in retrospect. What was more devastating to me, more scary to me, what gave me nightmares and still give me nightmares was when my children, my two boys who were 16 and 18, were driving to school one day and they were stopped by the Atlanta Police Department. My children, I only have two boys. And they text me. They said, Mommy, the police, I was like, oh my God, don't text, put your hand, because we had the discussion, hands on the dashboard, all the things to do. But they text me to let me know that they had been stopped by the police. And I can tell you all as a mother, for anything in life that we accomplish and achieve as professionals means nothing if your children or loved ones are there and you don't know if they are going to survive an experience. And that 3 of the most difficult minutes of my life. So I say to everybody on this panel, this is a global issue. It's a pandemic that we as lawyers, I believe, must address. We must address. So on behalf of the MBA, I want to say, to everyone, thank you for attending. And on behalf of the MBA, j'aimerais remercier tout le monde. Je vais parler en français parce que nous sommes une organisation internationale.
Oui, bien sûr, c'est notable.
Oui, bien sûr, c'est comme ça, oui. J'aimerais remercier tout le monde pour votre participation et aussi pour la discussion qui était très honnête aujourd'hui. So I just wanted to say, just for a moment, I want you all to know that our international conference is going to be a trilingual conference where we welcome people from around the world to talk about these issues. Just had to throw a little something in there because we have our friend here who's in Geneva, and I want to invite all of you all because our Chairman Woods is going to play a strong role in this conference to participate, especially our students, our Howard University students, and all students, because by that time, every BALSA student in this country will automatically be a member of the National Bar Association for free unless they opt out by the time our international conference takes place. So I want to thank everyone again. I want to say to Akua Kapak, who worked also with Chairman Woods, thank you. To all who had hands in this, I want to say thank you, and thank you for elevating the brand of the National Bar Association and addressing these important issues, because we're going to be leaders on everything, no matter where we are. But I want us to elevate our profile on these issues because we have so many of our members who have so much to say and have done so much. And then also, I did pose a couple of questions and you might have thought they were insightful questions, but I must give credibility and credence and thanks to Senator Arthenia Joyner and to former Justice Peggy Quince, because they helped with the framing of those issues. I'd love you all to think that I thought about it myself, but I've got to give credit to our leaders and extraordinary jurists, judges, senators who paved the way for us to be able to have this discussion in this country. And also, I want to recognize those extraordinary NBA members who are leading every single police brutality case that you see nationally and internationally. National Bar Association members and leadership. Of course, we got to take credit for that because they are just doing such an extraordinary job. So Chairman Woods, I'm going to throw it back to you. Those are my comments, and thank you again for all that you've done.
Oh, no, thank you. And thank you all for tuning in. We will be following up shortly, as President Hoffler stated. We'll have a conference in May, and we will let you know accordingly. Thanks again. Have a great day.